Hello there, this is Professor Nathanson. Welcome. This short video is going to discuss the jury right in federal court in civil actions. All right, let's reduce my smiling face and let's look at some of the key language. What we're going to do here today is talk about the Seventh Amendment, some cool things to know about it, some modern complexities, and then how the FRCP handles the assertion of the jury right, and some cool twists on it as well. So let's get started. Seventh Amendment says, in suits at common law, all right, well, what is that? Where the value in controversy exceeds $20, the right of trial by jury shall be preserved. What does that mean? And no fact tried by a jury shall be otherwise re-examined. What does that mean? In any court of the United States than according to the rules of the common law. All right, well, I've highlighted some of the key words, and we're going to be talking about some of these words a little bit. Here's the first fun fact about the jury right under the Seventh Amendment. It doesn't protect a jury right for criminal trials. But that's okay because the Sixth Amendment provides a jury right for criminal trials. Also, you might be surprised to know that the Seventh Amendment jury right in civil trials applies only in federal court. Well, why is that? Well, here's a little bit of basic common law for you. The first 10 amendments contain a number of rights. We call that, of course, the Bill of Rights. The Bill of Rights actually, as originally written, applied only as against the federal government. So the right to free speech, First Amendment, was a protection against the power of the federal government that might be misused to deny you free speech. However, after the Civil War, the 14th Amendment was enacted. And the Supreme Court has used the 14th Amendment to do what's called incorporation, which kinds of incorporates Bill of Rights, like free speech, and applies them not just against the federal government, but through the 14th Amendment, they also apply against state governments. So many of the rights under the Bill of Rights, free speech, right, freedom of religion, and so on, many of the rights under the Bill of Rights apply not just against the federal government, but also against state governments as incorporated, kind of channeled through the 14th Amendment. Well, the Seventh Amendment is not one of those. So the Seventh Amendment does, within its limits, provide a federal jury right in federal court, but does not require state courts to do the same. Now, of course, a lot of states do guarantee a jury right and their state constitution, but that would be under state law. All right. Another cool thing to note about the jury right under the Seventh Amendment, there is an amount in controversy. An amount in controversy of $20. How about that? Now, let's delete some of these words here. All right. And note the words common law appear several times in the Seventh Amendment. Well, you think, oh, well, that must refer to common law of the United States, historical common law. And, why do I say historical? Well, here's another key word, preserved. The right to trial by jury shall be preserved, under common law. And it would be perfectly reasonable for the new student to think, well, preserved, okay, I get that. That seems to require a historical test. The Seventh Amendment was ratified in 1791. Okay. I guess we'd have to look to what the colonies or the new states did in 1791. But that's not how the Supreme Court has decided that we have to analyze the scope, the metes and bounds of the Seventh Amendment right. Instead of looking to what the states were doing in 1791, we're supposed to do what English courts did in 1791. So actually, when looking to the scope of the Seventh Amendment jury right, courts will look to English common law as it existed in 1791. And as we'll see a little bit later, that's going to make for some weird complexities, because our court system today is very different from how English courts were structured in 1791. Okay, but our first big lesson here is the word preservation means we have to do a historical test, and the Supreme Court has said common law refers to what happened in England, English courts in 1791. Yes, that is pretty wacky. I would quite agree. All right, give my computer a second. Sometimes it gets whack itself. All right, so we got to look to English common law as it existed in 1791. I noted that this refers to a legal structure that no longer exists. Well, what is that? Well, back then in England, we had basically two court systems. And in fact, for a long time, U.S. courts were very similarly structured. We'd have courts of law and courts of equity. Basically, in England, a court of law would have a judge and would decide forms of action, like replevin, trover, trespass on the case. Those of you taking torts, taking contracts, when you read those super old cases, you'll see reference to some of these old writs for these old forms of action. Well, those were decided by courts of law, by judges. The typical remedy in a court of law, typically, was money, right? You proved a violation of some writ. You were entitled to recompense for your damages, which meant you would typically get money. Well, there was a parallel system in England, which existed in the United States for many years as well, which was courts of equity. Now, a court of equity, I think you already have a pretty good sense of what that is. A court of equity was one that administered equity, provided relief in the form of equitable remedies. So that would include, for example, injunctions, specific performance, right? An injunction telling the defendant to do something or to stop doing something. That was the essence of injunctive relief. And historically, courts of equity were not rooted in courts and judges. They actually were courts of chancery, courts run by the king's or the queen's chancellor, right? So maybe you've watched some, TV shows or read books about historical figures like, Sir Thomas More, now St. Thomas More, or Thomas Cromwell, right? People like that who served as the king's or the queen's chancellor, they would basically be the person to whom you would appeal when you had some sort of wrong done to you and you needed some form of exceptional relief that could not be remedied by a court of law. Does that sound familiar to you? Our test for granting an injunction is some sort of harm that cannot be adequately remedied solely by money, and you need something else such as an injunction. Well, what you would do back in the day is appeal to the chancellor himself, right? And then he could then grant that relief as a representative of the king or the queen. Now, eventually, of course, the chancellor, being a busy person, would then delegate that responsibility to subordinates, right? Thus leading to the development of courts of equity. Well, okay. Now that kind of tells us a little bit about weirdness that's going on here. If we have to look to what's going on in England in 1791, and the Seventh Amendment has a historical test, and the jury right only applies to suits at common law, then what that meant is the jury right only existed for things that could be heard by a court of law in England in 1791. So that makes things kind of nuts, right? That makes things kind of nuts. And we'll get to that in a while. But I want you to think about how in a modern lawsuit, you don't go to a federal court of law for money and then to a federal court of equity for equitable relief. You just file a civil action and you can seek all the remedies and all the relief and lump all of your causes of action together under Rule 18a. So, in modern courts, we don't have separate courts of law and equity. Well, what does that do to the jury right? And equally so, if we have to look to England in 1791 to determine what kind of suits give rise to a jury right, then we have a real head-scratching moment, right? Because so many of the modern causes of action that we have today in a federal court, such as environmental lawsuits, right? Or an employment discrimination lawsuit, or say a ADEA claim, Age Discrimination and Employment Act claim. So many of our modern causes of action, particularly statutory ones, they didn't exist in England in 1791. So how do we figure out which of those causes of action have a jury right, especially when somebody is seeking both monetary relief and equitable relief, right? So we'll get to that in a minute. But what we're kind of queuing up right now is this idea of preservation, right? So we know the word preserved combined with looking to suits of common law, combined with the fact that we look to English common law in 1791, that means we do a historical test. Now, there is another key part of the Seventh Amendment that I'm not going to really talk about right now, because we'll talk about a little bit more when we get to motions for new trial, when we get to motions for judgment as a matter of law. So we're talking Rule 59 or Rule 50 here. We'll get to that later in the semester. But this last clause of the Seventh Amendment asks, or rather instructs us, that no fact tried by a jury shall be re-examined otherwise than according to the rules of common law, right? So that implicates the motions for a new trial. That implicates judgment as a matter of law. The short of it is the Supreme Court has held that a new trial motion or a motion for judgment as a matter of law, also known as directed verdict or judgment notwithstanding the verdict, those comply with the Seventh Amendment, and they're written to comply with the Seventh Amendment. So I'm not going to get into this last clause. We're really just going to focus today on the first clause up through the word preserve. All right, so we understand that we need to do a historical analysis, but it's just kind of problematic. Today, under the FRCP, here's Rule 2, says there is one form of action, the civil action. And you look at that as a law student today, and you think, well, duh, of course. What's the big whoop, right? Who cares? This is actually a big deal. This is, in this one little sentence, the rule makers in 1938 accomplished what's called merger. The merger of law and equity, which meant there was no longer any distinction between courts of law and courts of equity. And in fact, prior to 1938, a federal court, say the Southern District of Florida, would sometimes say, we are sitting now as a court of equity, now we're going to sit as a court of law, right? They would kind of put on their equity hat and their law hat. No, they did not actually have a hat. If they did, then yay for them. But they would kind of function as one court and as another. It would be the same judge, the same court, but they were still kind of making that distinction between, I'm a judge and now I'm acting as a court of equity, and now I'm going to sit on my law side, whatever. Well, that kind of silliness was gotten away with, or done away with, in 1938, and there is no longer separate writs or forms of action. There are no longer things like, you don't have a suit in replevin, you don't have a suit in trespass. Instead, you file a civil action and you assert any claims you have, right? Which might include trespass and breach of contract and unjust enrichment or whatever, right? But this merger of law and equity in 1938, it was intended to simplify things, and for the most part it does, but it tremendously complicates the analysis of the Seventh Amendment jury right. For example, what about cases involving both legal and equitable issues, right? Who decides common issues first? Say, for example, P sues D for trademark infringement. 2 men in a truck, right? Plaintiff seeks an injunction. That's equitable. And monetary damages. That would typically be heard in a court of law. Well, under English practice in 1791, it would seem that the injunction would be something that did not have a jury right. That was decided by a court of equity, no jury right. But the money relief would be something that would probably be sought in a court of law in England in 1971. And that would mean you'd have a jury right, because again, the jury right says in suits of common law, the right to trial by jury shall be preserved. And English common law in 1791 meant the English courts of law, which would give you the money, but not injunctions. Okay? Well, under merger, after 1938, P could sue D and say, hey, my trademark was infringed. I want money and I want an injunction. So who decides? And who decides first, right? Because if the judge decides all of the equitable issues first, whether to give an injunction, well, that would include deciding issues that would also be relevant to deciding whether money should be awarded. For example, in order to issue the injunction, the judge would have to find a likelihood that the plaintiff would succeed on the merits of the trademark claim, which would require addressing, are the two trademarks similar, right? Is the defendant's trademark, if sufficiently similar, going to confuse or be likely to confuse or deceive the public, right? Then the court issues the injunction. The judge issues the injunction without a jury. And then it's time for the jury to step in and decide any remaining issues. But what issues remain? The judge has already decided that two marks are similar and that the public's likely to be confused by the similarity of the two marks for those goods or services, right? So the judge, if we allow the judge to decide equitable issues first, that would leave little to no issues maybe for the jury to decide. So what issues we have? Well, are the marks similar? Judge decided that for the injunction. Is the public going to be confused by a likelihood of confusion? Judge already decided that. Nothing left for the jury to decide, I guess, besides the amount of the damages. Well, the Supreme Court has rejected this kind of put the judge first kind of ruling. Instead, normally, says the Supreme Court, we're going to let the jury decide the common issues. So here's our trademark infringement, right? We have these common issues of how similar are the marks, that's number one. And is the public likely to be confused? That's issue number two. Well, being that these issues of fact are relevant to both the jury issue of damages and the equitable issue of the injunction, normally we're going to, number one, have the jury find those issues first. All right, the jury's going to decide. And then the judge will be bound by those findings. And then the judge gets to decide any remaining kind of cleanup issues that are relevant to the granting of the injunction. So say the jury says, oh yeah, the marks are similar, right? Trademarks are similar. Yeah, the public's likely to be confused. Then the judge would be bound by those. And then in deciding whether or not to give an injunction, the judge would then make the further findings of would an injunction be appropriate, right? Okay? So that's one of the ways courts have tried to deal with the merger of law and equity, is that when issues overlap, they're common between judge and jury. When they're common between issues of law and issues of equity. When an issue is relevant to both giving money and to giving an injunction, then normally speaking, the jury will decide those issues first, and then the judge is bound by the jury finding, and that way we help to preserve the jury right. Now note that the word preserve here isn't really mean things will be exactly the same as they were in 1791, because the court structure itself has changed since 1791. But we're at least trying to stick with the spirit of how things would work. Now, some of you might think, well, what about Two Men in a Truck itself, there was a motion for a preliminary injunction. And when a judge did decide that, did the judge have to bring in a jury to decide those issues so the judge could decide whether or not to give a preliminary injunction or not? And the answer there is a judge will decide the facts for a preliminary injunction motion. But then later on, when there's a motion for a permanent injunction, it's going to be the jury that gets to decide those facts. So the jury is not going to be bound by the findings made by the judge on the preliminary injunction. But later on, when we have an actual trial on the merits, the jury will decide the common issues that are relevant to money, to issues of law. And then the judge, when deciding whether to grant not a preliminary injunction, but whether to grant a permanent injunction, the judge will be bound by what the jury has to say. Okay? So that's how that would work. Remember, a preliminary injunction doesn't need a jury at all, doesn't get a jury. A preliminary injunction is going to be on a partial record. It's meant to just preserve the status quo, or at least prevent further tremendous harm pending the resolution of the case on a full trial, right? So, what I'm saying here doesn't matter for preliminary injunctions. A judge will still decide those facts, but then the jury is not going to be bound by those facts later on. And we have the actual real trial. Jury is going to find the facts, and then the judge is going to find any remaining equitable facts, right? But again, the jury finds facts that are relevant to legal issues, right? To legal issues, which then kind of begs the question, like, what kind of issues and what kind of causes of action are ones that qualify for the jury right at all. So, we've talked about merger, right? But there's a broader question about, how do we know if something is even qualifies for a jury right in the first place? Well, it's easy if the cause of action existed in England in 1791. So, for example, gosh, I'm not a legal historian, but I would assume, for example, breach of contract existed in England in 1791. I do believe it did. Battery existed in England in 1791. I'm pretty sure, right? So if something existed in England in 1791 and it deserved a jury right, then that's easy. That's not an analysis. That's just kind of like a little bit of historical research if necessary. But what about new causes of action that post-date 1791? I noted some, like a age discrimination in employment act claim, or an AD or a Title VII employment discrimination based on race or national origin, or sex discrimination, right? Or you can go on and on. And those things did not exist in England in 1791. Well, the Supreme Court still allows many of those causes of action to potentially qualify for a jury right. And what we need to do is do historical analysis under the Terry test. That comes from a Terry versus Teamsters, I believe, case in the Supreme Court, which has two elements. Figure out what cause of action is the best historical analogy, right? The historical analog. What in England in 1791 is most similar to this modern cause of action, typically a modern statutory cause of action. All right, so we look at that. What's the best Old English historical analogy? And plus, look to the nature of relief. The Supreme Court has made clear the nature of relief is more important, which that kind of then tilts the test towards normally saying if the relief sought is money, jury right, right? That's not quite determinative, but it's kind of almost determinative, right? But I gotta say, I hate the Terry test. It's just a fat mess. It's awful. Here's my legal analysis. The Terry test is a crummy test because judges make lousy historians. For example, in the Terry case itself, all right, the modern cause of action was a union's duty of fair representation to its members. And the Supreme Court was all over the place trying to figure out, well, what's the best analogy to what was happening in England in 1791? Well, one was a suit to vacate an arbitration award. All right, that existed in England. Or a breach of fiduciary duty existed in England. Attorney malpractice existed in England. Breach of contract existed in England. And there were decent arguments that all four of these were an analog to a modern duty of fair representation to the members of a union, right? Well, two of these tilted towards equity, and two of these tilted towards law, right? So what do you do? I mean, it ultimately comes down to lawyering and indeterminacy, and something as important as the jury right should be a little bit more predictable than this. You know, it almost comes down to, I don't want to be cynical and say about how many votes you get, but, you know, judges are not historians, and what we're trying to do is put round pegs into square holes here, right? So one of the justices, I believe it was Justice Brennan, made a very good argument that we should just look to the nature of the relief, right? Seeking money, jury. Not seeking money, no jury. Make a nice, easy test. There's a lot to be said for, I'm very sure it's Justice Brennan's argument here. The court has not accepted it. So, you know, you can send me the thank you note later. We're not going to read the Terry case. It's a hot mess, right? All right. So, you know, in sum on the Seventh Amendment right, you know, it applies in federal court. There is a jurisdictional amount of $20. It requires a historical test. And the historical test is not too hard if a cause of action existed in English courts of law in 1791. But if you have a historical analogy, then it gets a lot more weird, right? Also remember that because of merger of law and equity, a judge can hear lawsuits seeking both money and equitable relief. But what that means on trials on the merits, right, then we got to give typically the jury the first crack at finding facts relevant to issues of law, seeking money, right? And then let the judge decide any other issues that hadn't been decided by the jury. So, you know, I guess that means normally the judge is kind of the cleanup hitter, right? Use a baseball analogy. The one who cleans up after the jury has decided issues. All right. Let's see, what else? I think that's enough on the Seventh Amendment jury right. The courts have usually been pretty strict on enforcing the jury right. They tend to favor finding a jury right. Obviously, there's some scholars that suggest that juries are not always a good thing, particularly for really complex trials, like a securities trial or a patent infringement trial. There have been some arguments that there should be complexity exceptions to the jury right, that there would not be a jury and instead you'd have a judge decide things. That's an issue that's kind of beyond the scope of today's discussion, so I'm not going to get into that right now. Anybody who's interested, write me. We can talk about the Markman case, which concerns patent and patent claim construction. You know, but courts as a whole have courts for the most part, I should say, have really rejected complexity exceptions. There is some jurisprudence out there, a little bit to the contrary, but you know, as a general rule, the jury right is pretty respected as a huge part of the American system, and indeed, it's one of the rare ways that the general public gets to be involved in being a lawmaker, right? You know, you're part of the government. You know, the judge is bound by what you decide, and that's a big responsibility. And by the way, so is voting. So you're watching this because I wanted you to vote today. So I'm glad that you voted. Let's sum up this video with just a few things about the FRCP itself. How do you make a jury trial demand, right? All right, well, a written demand not later than 14 days after the last pleading directed to the issue is served, right? So, for example, here is a complaint, right? Here I screen capped a court complaint from a pleading, you know, this one, McDonald versus UPS. Well, there you go, jury trial demanded. And then later in the complaint, there would be a line saying that a jury trial is demanded for all issues on which a jury right exists, or maybe on specific issues, right? So, you know, you could just demand jury trial on all issues so triable, but you could also specify the issues on which you want to have trial by jury. right? Now here's an important one. You waive the jury trial right if you do not properly demand it in terms of when you demand it, how you demand it, right? You can also, of course, withdraw a jury right demand, but only if the parties consent. All right? About when no demand is made for a jury trial, right? You know, one or the other parties could have demanded a trial in a civil action, but they forgot, right? Well, then here's a couple options. The court has discretion if there's a motion, right? If there's a motion, then the court can order jury trial on any issue for which a jury trial might have been demanded. So if the parties waive a right to a jury trial, and then one of them realizes later on, oops, we screwed up, or you know what, they decided not to request a jury trial, but they changed their mind, now the time maybe has elapsed for demanding the jury trial as of right, well, they can still ask the court to allow a jury trial on any issue on which they could have demanded but failed to do so. But Rule 39C goes even further than that. Sometimes courts can order advisory juries or actual juries for issues on which there's no jury right at all. Okay, so in an action not triable of right by jury, the court, either on its own or via motion, can impanel an advisory jury and try any issue with that. And then the advisory jury would, of course, then decide the issue. And then the judge would not be bound by the advisory jury, it would appear, but would have the benefit of what the advisory jury has to say. All right? But also, note trial by consent. Putting aside an advisory jury, the judge may, with the consent of the parties, try any issue by an actual jury. And now the jury is going to decide it, which would have the same effect as a jury trial. And this would be for issues, that aren't triable by jury at all. So, for example, maybe the court gets a motion to have a jury decide whether or not to give an injunction, right? And the parties consent to have a jury decide whether or not an injunction should issue. Then the court may, after that motion, with the parties' consent, try the injunction by motion, because that's an issue being tried by a jury, and its verdict would have the same effect as if a jury trial had been a matter of right. But of course, an injunction is typically not something which has a jury trial as a matter of right, but under FRCP 39C2, the parties can move and consent to a jury trial anyway. So we can have a jury trial then. All right, so that's about half an hour in. That's the video. I hope this is helpful. Have a good day. As they say, vote early. Do not vote often. We get one vote. All right, guys, take care. Be well.